May it please your lordship, I beg to mention for listing of a criminal appeal.
Criminal
Appeal, lordship.
for?
For orders.
Okay.
Orders call.
Next to both sides.
Please your lordship, I beg to mention item 8.
Item 8, my lord, I am for a.
Yes, by order.
By order. By order. I paid the amount, but
Okay, you wait for your turn.
Lordship, actually,
Actually-
instruction, kindly allow us some time, 2 days' time.
You wait for your turn. We'll find out from them. Thereafter, we'll allow you time. Be there. You're running short of time or what?
Item 23
23.
for hearing, Lordship. Some report was called for, Lordship.
23 report was called for. No?
The next APP has received some report from the forensic science lab.
Six 2023. 6/6/2023. Whether the exhibits reached FSL or not?
Lordship, I have got some communication from them.
No, whether the learned special judge was directed to heard MSA Devi.
Lordship, may I pray? Direction will be given to the learned district and session judge. Forward, it should go from the registry, your Lordship.
The question is somewhere it is lacking. Report is addressed to the prosecuting inspector, right? And director in charge has said in the letter addressed to the district and session judge that as per instruction of the SP, the report was collected along with the exhibits by one ASI.
Only Sena Sinha.
Right.
Yes. Whether it was delivered to the.
I think the authorities which are mentioned, I think you should take a report from them. Learned Legal Aid Counsel for the Appellant and MS B. Bhuyan, Learned Senior Counsel and Additional Public Prosecutor, assisted by MS M. Chakravarti, Learned Counsel for the State Respondent, are present. Post up. By in deference to the orders, comma, dated 6/6/2020, comma, dated 1/8/2023, comma, dated 11/9/2023, comma, dated 27/9/2023, and dated go to the end, and dated 21/11/2023, comma. Another order was passed on 22/03/2024. No. I go to the end. Past number to I go to end. Another order was passed on 21/11/2023. So, as per the said order, comma, the special judge Nagaon was requested to take steps for having exhibit number, SERO, SERO dash 3627 stroke capital C, comma, exhibit number SERO dash 3627 stroke E, comma, exhibit number SERO dash 3627 stroke D, and exhibit number SERO dash 3627 stroke I. examined by the Forensic Science Laboratory, Kailipara, and to submit a report as regards matching of sperma.
May I please your lordship, Miller, for listing a criminal appeal for orders, Miller. Any date in next week, Miller.
Next.
Obligation. Orders. For orders.
For orders.
Orders.
May it please your lordship.
Hmm.
Lordship, I beg to mention item number 24 of today's list, lordship. Lordship, this matter may come up next week, lordship.
Okay, on the prayer of Mr. T. Golita, learned counsel for the appellant, list appeal after we gonna date to fix matter office. A. Begum, the learned additional public prosecutor for the respondent state is present and has consented to the same prayer.
Lordship, may I pray for fixing a date, lordship, next week?
It will come accordingly after.
Yeah, okay, lordship. Criminal appeal for orders, lordship, next week, any date.
Next to next week.
Online.
Daily list for motion item number 1.
May I please your lordship?
Hmm. Yes,
May I please your lordship? Lordship, it's a contested matter and the impugned order is at page 29, lordship. The petitioner before the learned tribunal, lordship, has exhibited voters list of 1966 where his father name were appeared,
hmm. Barek
Barek Ali, lordship.
Ali.
Yes, lordship. He originally hails from the district of Darang, lordship. Because of his livelihood, he went. to-
Contested matter.
Yes,
Yes,
lordship.
Mr.
Lordship, may issue notice at this, please.
And lordship, I'll humbly pray for interim lordship. Linkage is very clear.
Yes, interim bail.
Yes, lordship.
Yes.
Lordship. Lordship will kindly see para 7 and 9, Lordship,
Para 7 and 9.
of impugned order, page 32. Then tribunal found that age difference between father and son is 4 years, Lordship.
Age discrepancy is prevalent in most of the voters list, lordship. Even in my personal voters list. age
We will not go deeper at this stage
Yes,
in
lordship. Yes, lordship.
biological science subjects.
Yes, lordship. Yes, lordship. I humbly pray for you.
Heart. MSD Ghosh. Learned counsel for the petitioner. Who is for one?
One Union of India, Lordship.
Who appears normally?
Lordship. So many councils are there.
Tell me.
They are allotted different, in every day, different LOPs representing Lordship.
Then
Madam can appear, Lordship,
foreigner matter you appear
for Union of India.
or otherwise Architect Chudri.
Lordship.
Architect Chudri will do.
Yes, yes, Lordship. That's it.
Architect Chudri. Learned Deputy Solicitor General of India. For the respondent number 1. Home Department.
And for two.
Mr. Z.
G. Sharma.
Z. Sharma. Learned Standing Council. Home and Political
B.
Department. For the respondent number
2, 7 and 8. Lordship.
2,
Seven,
7 and
8 and 9.
8. 8 and 9.
Yes.
9. Okay.
Each fully on behalf of AIL for the election.
Ali is there. Mr. A.I. Ali.
Respondent number 3.
Learned Standing Council, Election Commission of India.
Yes.
For the respondent number 3. Now NRC. Huh?
And regarding NRC,
Now that they don't have any separate standing council.
Okay, the Architect Jury. Or MS Devi, you are Central Government Council. You appear in foreign matter. Architect Jury, okay. MS Devi, Learned. You are also CGC? Okay. Learned Council representing Mr. R.K. Devchuri, Deputy Solicitor General of India for the respondent number 1 and 4. Then who is for 5 and 6?
I can represent.
5 also?
5 also.
Jorhat, DC Jorhat and DC Dorong,
yes, sir. He will appear.
Mr. Sharma,
Talukdar.
R. Talukdar, Junior Government Advocate. For the respondent number 5 and 6.
5 and 6.
Complete?
Yes.
Okay. This petition has been preferred against order dated, against order stroke opinion dated
26/12.
26/12/2023. Passed by the learned member, Foreigners Tribunal at Jorhat in case number FT, page 29 of the FT stroke SBR stroke 3012 stroke 211, declaring the petitioner to be a foreigner of
Post 1971 stream.
post 1971 stream, full stop. MS Post Clerk Counsel for the petitioner has submitted that the case FT so and so is a contested matter, but despite you adduced evidence,
Yes, Lordship.
despite submission of written statement and adduction of leading evidence, sufficient evidence on behalf of the petitioner, stroke proceedee, so as to establish the claim of citizenship, his case has not been considered in correct and proper perspective, and the learned tribunal has urged in law and in facts in rendering the opinion, full stop. Upon perusal of the materials available on record, we are of the considered view the matter would require further examination, issue notice returnable on in 4 weeks.
Yes, Lordship.
Since all the respondents are represented by their respective counsel, issuance of formal notice to the respondents are dispensed with. However, learned counsel for the petitioner shall furnish extra copies of the writ petition in requisite number to the learned counsel representing the respondents within 3 working days from today. Full stop. LCA is to be called for.
Yes, sir.
Yes.
Yes.
Okay. The records of case number so and so FT, page 29. Be called for heard on the interim period, full stop. Having regard to the facts and circumstances projected on behalf of the petitioner, it is ordered, as an interim measure, that in the event of arrest of the petitioner shall be allowed to go on bail subject to furnishing a bond of rupees 5,000. What is the standard?
5,000.
5,000. And appearance before,
SP Borders.
Dorong Lordship,
respondent number
respondent number Lordship, respondent number 8 Lordship.
8.
Yes, Lordship.
Appearance before the respondent number 8. That is, comma, the superintendent of police, border, Dorong.
Dorong Lordship.
What to do then before him?
He has to appear with surety and everything.
Okay,
They can-
within 2 weeks from today. For the purpose of,
Taking biometrics.
for the purpose of capturing his biometrics
Yes, Lordship.
and
He will-
Both the iris.
Irish, yeah.
iris of both the eyes.
Yes, Lord.
Okay, iris of both the eyes, full stop.
Including fingerprints.
Hmm?
Including fingerprints.
That they will.
Fingerprints also.
Yes. Lord.
Okay,
Finger-
biometrics, comma, iris of both the eyes and the fingerprints. Full stop.
Biometric come with fingerprints. only.
I don't know what is biometrics.
With fingerprints and everything,
Okay.
Lordship.
And whatever the others,
Deeply applied.
one, the second, same. Well,
Yes, your Lordship. Yes.
respondents are similarly ordered or what?
All are contested. Yes, Lord.
No, I'm asking that
Yes.
respondents are similarly arranged or
Yes.
different? Okay, different. Yes, MS,
And Deca, your lordship.
M Deca
And Deca,
and Deca.
your lordship.
Okay, petitioner. LDB, Hmm?
1 and 4.
representing so and so, 1 and 4. Z Sharma,
2, 6, 7. 2, 6.
2, 6,
and
7.
Yes. Okay.
AI Ali, Standing Council, ECI, Election Commission, 3, and Mr. R. K. Talukdar. R. Talukdar, Learned Junior Government Advocate for the respondent number 5. Opinion of page 2 court. Opinion court. Opinion to court.
Page 30, your lordship.
Page
30, your lordship.
30.
Yes, your lordship.
Order stroke opinion dated 29/01/2024. Learned member, Foreigners Tribunal, Fort Gwalpara, Assam, in FT case number, page 30. FT within bracket Z dash 4, bracket close, and stroke 443 stroke 18 by NSM. By NSM.
Your lordship, in the item 2, a similar matter, which is of the brother of the petitioner is also pending before this honorable court.
Let the notice come, then you take both.
Yes, your lordship.
Here it is. I go to here.
Bongaigaon, your lordship.
Parties are same or different?
Yeah.
Different. And Deca, petitioner. LDB representing Architect Chudri,
1 and
1 and 4. Z Sharma, Standing Council Home and Political Department, 2,
6 and 7.
6
And 7.
and 7. AI Ali, Standing Council, Election Commission, 3. 4 to 1. R. Talukdar, Junior Government Advocate, Assam for respondent number 5. Opinion
Page 29, your lordship.
29. Order opinion dated 3/8/2020.
Yes, your lordship.
Hmm.
Yes, your lordship.
Foreigners Tribunal, Bongaigaon, number 2, Abhayapuri. Case number BNZN stroke FT stroke 2711 stroke 09. Page 30.
Repeat your question.
Interim.
For admission item number
NMS A Begum. Learned additional public prosecutor for the respondent number 1, State of Assam. This criminal appeal is directed against a judgment dated 28/3/2024 and an order on sentence dated 30/03/2024 passed by the Court of Learned Additional Sessions Judge Udalguri in sessions within brackets capital I, case number 123 of 2018, page 17 order. By the judgment and by the said judgment and order on sentence, comma, the 3 accused appellants have been convicted for the offenses under section 341, 323, 302 IPC, read with section 34 IPC. Suppose the accused appellants are have been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000 each, comma, in default of payment of fine, comma, to undergo simple imprisonment for another 3 months. Full stop. For the offenses under section 341 and section 323 IPC, read with 34 IPC, different terms of imprisonments. The accused appellants have been sentenced to undergo different terms of imprisonment. Full stop. It has been ordered that all the sentences are to run concurrently. Full stop. We have gone through the memorandum of appeal, contents of the memorandum of appeal. The criminal appeal is admitted for hearing. The case records of sections I, case number 123 of 2018 be called for. Issue notice returnable in 4 weeks as MS A Begum, Learned Additional Public Prosecutor, has appeared and accepted notice on behalf of the respondent number 1, State of Assam. Issuance of formal notice to the said respondent stands dispensed with. However, an extra copy of the memorandum of appeal along with annexes be furnished to MS Begum within 3 working days from today. The appellants shall take steps for service of notice upon the respondent number 2 by registered post with AD as well as by usual process within 3 working days from today.
My lord, one IA is also there, for bail.
You press after LCR?
Published.
Objection. Objection after receiving.
Otherwise, it will be difficulty for you or what?
No.
They have annexed all the evidences. They have annexed here,
So they have, judgment is there. yes.
only judgment.
Published.
Okay, after you press that after LCR.
Right.
item number 6.
Six.
My lord, appeal against conviction, my lord.
BB Najari, learned senior counsel, assisted by Mr. S. Sohan, learned counsel for the appellant. NMS A. Begum, learned additional public prosecutor for the respondent. Number 1, State of Assam. এই নোটিফিকেশনখন 376 D আছে নেকি এই নোটিফিকেশনখন
Conducting counsel B. Borua, he is another court.
heard MS as Deka, learned counsel appearing for the accused appellant, and MS A. Begum, learned additional public prosecutor for the respondent. Number 1, State of Assam. Post of this criminal appeal under section 415 within bracket 2 of the Bharatiya Nagorik Surakha Samhita 2023 is directed against a judgment. Page 55, judgment in order. The judgment dated 8/7/2024 and an order on sentence dated 10/7/2024 passed by the Court of Learned Sessions Judge Udalguri in Sessions case within bracket capital I or Roman 1. Number 53 of 2018. Also by the same judgment and order, the accused appellant. Convicted under
302, Your Honor.
convicted for the offense under section 302, Indian Penal Code, and he has been sentenced to undergo 88. Undergo rigorous imprisonment for life and to pay a fine of rupees
20,000.
20,000, in default of payment of fine, to undergo simple imprisonment for another 3 months. First up, we have perused the Agordo recently contents, admitted, case records, call for, issue notice 4 weeks. A. Begum accepted notice, issuance of formal notice dispensed with, extra copy. Then the accused appellant shall take steps for service of notice upon the respondent number 2 by registered post with AD as well as by usual process within 3 working days from today.
Has filed the Wakalat Nama, and she has been represented by advocates, I suppose.
Okay. Heard MS S. Boss for Bujari,
Bajari.
learned amicus curiae for the appellant, and MS A. Begum, learned additional public prosecutor for the respondent number 1, State of Assam. None has appeared for the respondent number 2, though the names of the learned counsel are reflected in the cause list. As per the office note dated 16/5/2024, service of notice upon the respondent number 2 has been duly effected by the officer in charge, York Police Station, District Jorhat. As the paper book is ready. The office to list the appeal for hearing in due course. Office to furnish a copy of the paper book to the learned counsel for the respondent number 2.
Lordship, obliged lordship.
A public prosecutor. And if we see 325, I think 325 or 225, trial to be conducted by public prosecutor.
Public prosecutor.
And there is a difference between public prosecutor and additional public
Additional.
prosecutor. An opening case for prosecution. It is the public prosecutor who shall open
Open the case. madam.
then conduct the case.
Mm.
A strange situation has occurred there. Now, have you gone through, Mr. Ahmed, through this criminal manual? There is a procedure. We have to, because it is not only your 2 cases, there are other cases.
Other cases. Well, what we
We are-
have seen in practice, my lord, what happens when the public prosecutors are appointed In the case of the High Court, it is with the.
Seen is not what is laid down.
Laid down, my lord.
I want what is laid
Laid down.
down. What is seen, I also know. Laid down will not serve the purpose.
No.
What is, oh, sorry,
Seen
seen
will.
or what is normally done. These are not.
No.
The division bench.
The court had- Which paragraph?
In between, but middle portion of it. Attempt of repay, how it has to be given. Yeah, but the plan is not- Character of the social-
MS Bhuya, the report has come or not? Report.
It's come, my lord.
I think in which case, Mr. Ahmed's
Ahmed's
case?
Ahmed's case. Take it from her also. I was there.
Because it's a case of, it should be a combination of both. Justice delayed is justice
Denied,
denied, and justice hurried is justice buried.
married.
So it should be a combination of balance of the two. It should be a balance. Your trial was from which period?
My lordship, 22 to 2022, charges were framed.
20
22 February 2022.
and ended on
Ended on lordship,
charge was framed on?
charge 22nd February 2022.
Okay.
And judgment delivered on 31 2023.
Then MS Mia,
Hello,
you get this on record by affidavit.
yes. Hello.
From the report of the district judge, it appears that Mr. Daniel Das, he has drawn his retainer fees only till February 2022.
That is all.
And he has, report has been submitted by the district and session judge now present. And he has some differences with so and so. Complaint has been submitted everywhere, meaning thereby he did not participate in the trials. And a new public prosecutor was appointed only on 1/6/2023.
No,
So prior
prior to
that, your trial ended.
ended.
Similar is your case.
My lord, trial charges framed on 25/2/22 and judgment on my lord 24/8/22.
24/8/22.
22.
So same period. You file both the
Oh, shit.
in both
But,
an affidavit.
It's on by the Secretary Judicial Department.
I think it will be better. File the same affidavit in both the cases.
Yes.
Then it will be picture will be clear. Mr. Ahmed and Mr. Nawaz will not be responsible for your submission because then affidavit, if it, the record, then consequence will think of. Whether it should be, there should not be a face trial.
No.
That will think of.
Only one prayer, Lordship, can it be kept as part, already your Lordship had dealt it or maybe taken up
No,
a
no,
Friday?
it have to, but we are on the order stage. Let this formalities be complete, then we can start hearing.
On Friday.
Paper books are ready. Let this be expedited within 1 week. Then we'll decide. I'll be here at least for 3 weeks, so we'll decide.
Lordship.
10 days, I prefer 10 days.
Next day, any week, maybe fix on Thursday.
S. Nawaj, item number 10. S. Nawaj, Learned Counsel for the Appellate, and MSP Bhuya, Learned Senior Counsel and Additional Public Prosecutor for the respondent number 1, and MS L. Devi, Learned Legal Aid Counsel for the respondent number 2. Postal. Right, huh? MS Priya has submitted the CA a copy, a report. You place all this in this
Yes,
affidavit
yes.
that say so cause notice to Daniel Das, everything. Then letter of the secretary to the district judge, then district judge letter to the
Lordship.
secretary judicial, right? A report has been received from the Learned District and Session Judge. A report dated 24th June 2024 has been received from the Learned District and Session Judge Sirang, addressed to the Secretary to the Government of Assam Judicial Department, along with the other relevant communications. MS Punya has sought for 10 days time to bring the said record and the other relevant to bring the said report and the other relevant correspondences on record by way of an affidavit. First up, the prayer is allowed. Release the case on
27th.
27. 8. Sound, I am able to sound. A. Ahmed B. Bhuya. Same. Same, huh? A. Ahmed B. Bhuya. You are 302. Your is POXO.
Also 6 months.
Problem.
I'm declared.
And find out
My lord.
from here
Yes.
what are the provisions.
Criminal code order, my lord.
Yes, criminal.
Items 12 and 13.
Here in this case, Lordship, this interlocutory application has come up for consideration of suspension of sentence and grant of bail, Lordship. The case is based on circumstantial evidence, Lordship.
Let us have a look at the FIR first.
Lordship. On the other day, I have given one compilation, Lordship. That compilation page 1 is the FIR. And I am appearing for Rohim Ali Sheikh. Two persons named in FIR.
I have not understood what is this review of a relationship of father-in-law and son-in-law. Sattar Ali.
That is in village lordship, they develop some relation.
Sattar Ali give a relationship of father-in-law and son-in-law with my elder brother. Who is elder brother?
Deceased is.
Azhar Ali Mondal.
Lordship. Elder brother is deceased.
Azmanu Khatun, daughter of my elder brother, to his house. Thereafter, accused Rohim to kill my niece after committing rape on her. Went to the house of Israel to bring back his daughter. He did not find her in the house. When he asked about missing from his house, right? He informed us about the matter. When we came to Nunmati, PTP public, dead body was found. After dead body was found, the FIR was
FIR was
filed.
lodged.
And you are
I am for Rohim Ali Sheikh.
any the postmortem?
Yes, postmortem report lordship at page 41. Postmortem says due to drowning.
In a judgment, anything about postmortem?
Yes, that your lordship will find.
Autopsy doctor,
Page 85,
55.
85, paragraph 57.
85.
85, okay. In 85, 58 lordship, it is
50?
50, 57 lordship. Paragraph 57, page 85. That regarding whether it is homicidal or not, that is discussed.
Dead body was covered by dhari.
Lordship. Whether it was recovered in that state, that is not there. Lordship.
Hmm?
Whether the dead body was recovered at that state or subsequently it was wrapped, that is not there in the evidence. Lordship.
Where is the evidence of PW9?
PW9, your lordship will find at page 19.
What is the evidence of the doctor?
Doctor Lordship,
Page
that
15.
PW 7, page 15.
What are the circumstances relied on by the trial court?
Lordship, from the judgment, if your Lordship peruse, page 88, paragraph 63. Mainly relied on the circumstance of evidence of PW 10 and 9. 9 your Lordship has already read. And PW 10 is the father of co-accused Sattar Ali, Lordship. He stated that he heard from the
Page.
page 88, paragraph 63 of the impugned judgment.
Come to page 84.
Lordship.
Paragraph 56.
Lordship.
Subpara 2. Sattar Ali visiting the house of Azahar took victim Asbanu with him at his residence.
Lordship.
Where from this?
It is admitted, Lordship, that admitted fact that the victim was in the house of Sattar Ali along with her two brothers, Lordship. That co-accused.
Hmm?
PW 9 also says.
Huh?
PW9.
Appellant Rohim. So,
My senior has come, Lordship. Father of the girl was examined as PW 5.
who deposed about Rohim?
That PW 10.
Hmm?
Father of the And the learned trial court also considered the 164 statement of PW9 that your lordship will find at page 18A. That was recorded on 22nd May 2013. After about 1 year.
After about?
1 year of the incident. And while deposing, he says he stated as tutored by police.
I did so. No, I did not visit the hospital. That was. Yeah. More reliable on it. More reliable on it. See? Kaka conviction দিলে 17 দিলেন নাই Kaka conviction দিলেন who were convicted Sattar also
Sattar and Rohim Ali Sheikh, 2 persons convicted. Sattar is item number 13.
he is referring to convincing note he is brother Who is PW5?
He is the father of the deceased girl. There you look, page 11, Lordship.
So Asabanu was missing from the house of Satrali. Hmm? Hmm. Whether somebody deposed that Rohim was seen in the company of the deceased?
No, that is not there.
Extrajudicial confession of the accused person.
PW10.
PW10.
But he
PW8.
PW8?
Also.
PW10 is not very
PW8.
trustworthy because he said in cross-examination, village people disclosed that accused Rohim confessed killing of Asbanu. But it was not before him. The confession was not before him
It was before the.
by Rohim. PW10, though says about confession by Rohim, ultimately on totality we find that confession was not made by Sattar Ali, Rohim Ali, before him.
There's a 164 statement also. Dilbar, page 18.
And who else has said about extrajudicial confession?
That PW 9 in 162.
Huh?
PW nine in one
Page-
sixty.
Okay, then any other? Hmm?
That other was it PW one, he says. PW one, but the PW one and four is disbelieved by the trial court itself. 1 and 4, that is disbelieved by the trial court itself. Because of the living cross, they admitted that they have not heard.
PW8 is a hostile witness.
Hostile witness, hostile.
Girl went to the Sattar Ali's house.
Lordship.
Yes. Not
She
when,
remained
not-
there. She
when.
remained there.
Not when.
Huh?
They came and took her. This accused was.
Sattar Ali took the disease
Yes,
from the house of her father to his house.
my lord. They are having.
Then
some-
thereafter, she stayed there.
Yes. along
That
with
is the
brothers.
prosecution case. Apart from her minor brothers.
She was also.
Then
minor,
she
my
went
lord.
missing from the house of Sattar, right? And Sattar remained silent,
Sattar
regarding
remained
missing.
silent. Lordship. Even-
right? Then the father of Sattar,
Lordship.
PW 10,
Hi.
Then,
Father of Sata, yes, PW 10.
he said that Rohim appeared to have confessed before that he had killed. But that was not before him.
Not before.
Extrajudicial confession was not before the father of Sattar.
but on the relevant night, Rohim came to his residence. To
Where
the
from?
residence of Sattar, my lord. PW 10, my lord.
In cross, he said he has. not seen.
Cross, we have to read both. Both. Then he said in cross, when, where, and what time the dead body of young female was found, it is not known to me. No.
1, 2, 3, 4, 5. 6th line from bottom, page 21.
I did not see accused Rohim coming to the house of accused Sattar. I did not see accused Rohim taking away Azbanu from the house of accused Sattar. This is his evidence. So, on the other hand, 98 Carolina Tricode, the effect of the circumstance brought by way of evidence coupled with the extrajudicial confession of Rohimuddin before PW 10, we don't find any extrajudicial confession of Rohim before PW 10 because he says, page 21, village people disclosed that accused Rohim confessed killing Azbanu. Perhaps it was not before him,
Yes, your-
or he again denied also. Let us see again. Confessing murder of son, denied also. My son. In presence of villagers,
Presence of videos.
he is going to say that it is before him. Huh? I was present. When,
Lordship,
okay,
Some differences.
Okay. confessed, I was present. So it was prior to arrival of police. And no, but then he denied also again. It is not a fact that I did not hear accused Rohim confessing the murder of Azbanu. Village people disclose, he can say, but he denied. I was present. When accused Rohim confessed killing of Azbanu, I was present. So, but that part, Rohim taking away the girl from the house of Sattar, he did not see. But confessing part remained.
That is also doubtful, Lordship.
Huh?
That is.
It is different thing, but that remained. He denied.
Doubtful.
He denied in his cross.
Doubtful.
Village people as well as before him. That is one. Then what? PW 9's confessional state or whatever, statement under 164. That is not confession.
No.
Statement under section 164. These and other circumstances.
And on being asked by the father of the deceased, they denied, my lord, and as to what whereabouts of the victim girl. She was in their custody, my lord. She was aged about only 14 years.
Okay. We'll
Now,
come
should
back.
we have a look at the original and the, I may be wrong.
Ah.
And the copy.
Which one?
provided
This
by
one
the
is
PW10, original.
PW10. Okay.
Signature card.
PW10, we are given the certified
This,
copy.
it is there.
Original,
Same thing.
signature,
No, signature is not the issue here.
here.
Signature is the issue in 164.
164.
No.
Huh?
That original substantive evidence. As
P-
a-
You will come back.
Lordship.
Yes, 35 what is denied policy. P13 not. Question number 5. Yes.
There is nothing on record to connect the present application with the date of the. And there is no proper explanation that how the date of the victim can be taken as notice. The homicidal date. There is only the right one that it was there with Ariba. So whether when recovered she was there with that is not there in that. Or whether it was subsequently.
Who first saw the dead body? It was found in semi-decomposed state. Inquest magistrate semi-decomposed state, holy question. So maybe that is prior to discovery of the dead body.
There also laws after recovery and 50% of clear will inform about the recovery of this.
Yes, MS Punya.
Hello. Lordship, just now. I
Two
just speak about
circumstances,
this
one
PW12, Lordship will continue.
two circumstances basically. Extra judicial confession
Question,
as deposed by PW10
my lord.
and a judicial confession under 164 against
Okay.
Rohim.
Yes,
Against Rohim.
my lord.
Whose 164 statement?
PW9.
PW9. So basically a statement under statement under section 164.
My lord.
Loss is said, but as police records it, they depose.
No, that one he didn't say. Please, Kima.
Magistrate examined.
No, no.
PW 9.
Police produced me before the magistrate about, so it doesn't mean police tutor.
In his statement, he said that Rohim disclosed to him. Magistrate examined.
Oh.
No, who exhibited? Okay, he exhibited.
Another circumstance is the extrajudicial confession, which was before the public, whatever the contents, my lord.
No public except PW 10 was examined.
Yes. Lordship, but
So other public will not
no.
come into picture.
Lordship, but PW,
10,
yes.
father of Sattar.
Yes. So whatever the contents of that extrajudicial confession tallies with the when the dead body was recovered. She was tied with her, like the gamusha was there. In the inquest report, it was there.
Huh? Inquest report.
That is it. Lordship, PW 15. Page 33. 3, 4, 5, 6. Sixth line. The dead body was raped in a red cloth and a white gamusa was found wrapped around the neck of the deceased. Another factor, your lordship, before PW, the deposition of PW 12, page 23A. Information was given by Sattar Ali.
Deposition
Page
of
23, page 23A of his
23A.
of his compilation. A person named Sattar Ali gave an information to the outpost that his sister-in-law Asha Bhanu Begum came to his house but went missing from his house when she was sleeping. I made an entry so and so with regard to the information. And your lordship, from the evidence of IO, in 313 that question was put, question number 29, accused Sattar Ali surrendered. The subsequent day, dead body was recovered, my lord. On the following day,
Who is this Hasem Ali?
Hasem Ali. Yes, Hasem Ali Mondal PW1. PW1. Uncle of the victim.
So I, along with other police officers, went to the place where the dead body was floating. Dead body was lifted. Inquest on it was prepared by magistrate. So there cannot be any intervention in between. Dead body was lifted by IO, and thereafter inquest was done. So IO was present. So there cannot be any intervention in between by other regarding wrapping of gamusa or something like that.
And Sattar Ali surrendered before the IO.
Where?
From the evidence of IO. Lordship, page 23A. A person named Sattar Ali, oh, no, not that one.
That is the missing report.
Yes. Yes, page 22. PW 11. Accused Sattar Ali surrendered before the court.
Major.
Page 22.
Hmm. Against whom charges was submitted?
Please, there are 1, 2, 3. There are 4 IOs, my lord.
319.
There are 4 IOs, my lord.
তার মানে একটু ইন্টারভেনশন নাই রিকভারি তো আইওই করছে ফ্লোটিং এর পৰা পিডব্লিউ 12 এ করেছে মিসিং রিপোর্ট এটা আছে
Lordship, even fifth line, page 26B.
20
26B.
IO or which IO was confronted with
Page 26, the Sattar informed Salkusa police outpost about the death of Asabhanu.
This, after declaring hostile, PW8 was confronted with his previous statement by prosecution. Page 18. Then it was put to the IO also. It was put to the IO, PW 13 regarding extrajudicial confession of Rohim. PW8 was confronted after declaring hostile. That part regarding extrajudicial confession of Rohim before in his presence. So he is otherwise not inimical to you, PW8. Then that was put to the IO also when he was examined by the prosecution. Whether it is a case of weighing the evidence, because we are in 389.
Law regarding that extrajudicial confession, it is a weak kind of evidence.
Weak.
Weak and even here also it is of hostile.
Yes, that is what we dealt with. We dealt with that issue, how this part can be brought on record, that previous statement. It is declared hostile by the prosecution because he changes his version from his previous statement. Then it has to be put to him after declaring hostile, taking permission from the court. Then it can be brought on record by confronting with that part with the IO. Then it comes on record. And this extrajudicial confession fact is also deposed to by PW10. Weight of evidence, we are not going to. Weight of evidence is not going to how much 1 kilo or 10 kilos. Right. The question is, what is glaring?
Apart from the extradition, there has been some other circumstances to complete the chain of circuit. That only that extrajudicial
But whether extrajudicial confession, unlike confessional statement, is a substantive piece of evidence or not? Extrajudicial confession may be weak, may be weak. I'm putting the query. Confessional statement on its own, recorded under 164, is only can be used as a corroborative evidence. It is not a substantive piece of evidence under section 3. But so far as extrajudicial confession is concerned, it is under section 24. It is substantive piece of evidence, but weak in nature. These are the difference. Now, how much weight should we go in the stage of 389?
Conviction is there on that also.
Yes, but this appreciation of evidence is not a matter of 389. Real law otherwise. But appreciation of evidence is not going to be examined, picking up hole here, hole there, gap here, gap there. 389, whether clearing, trial court has placed reliance on extrajudicial confession. Yes, please. 8 আৰু 3 টো আছে না 8 আৰু 3 টো আছে তো আমি তো এতিয়া প্ৰেসক্রিপশন চাও 389 চাও let us see 389 আমি picking up hole there it is, but it is substantive piece, but weak, not corroborative. Page, opera. 8. But conviction can be based on extrajudicial conviction also. Law is also there. For the judgment of Sarda. 80 is Sarda. Ten. No, this is for the final hearing. Show me law regarding 389. Because we are not on final hearing, we are considering 389. So what are the parameters?
On Friday,
Friday will not be possible. This bench will not be sitting. Any day thereafter. Any day thereafter. Yes, Mr. Chaudhary, anything you want to add? Otherwise, he is covering everything. Anyway.
So far, the one is concerned. What they informed. What are we saying, my lord?
Because once a finding on conviction is made by the learned trial court, that presumption of innocence is gone. So far, we are 389. We are not on hearing. That then, what are the parameters? Oh, for that, what are the parameters for consideration of an application under 389? That is what we are.
So, what will you find? I am also saying on the 8 month. Because it is not hostel part, we are going to go to the otherwise, court below. There is the whole conviction on this because the 9 and 10. Only 9 and 10.
With 160, expect to see a. About Himalayan mother, in fact, nothing has come up, even the so far the PW5 is saying that my daughter, my two sons, they were sleeping together. From there, she got missing. Rohimali did not utter no whisper about Rohimali.
Hmm.
Go into the 89 matter for your worship, I've got every discussion and I to see my father.
A discussion is to be properly exercised. That is what we are.
Ultimately, only. That cannot be also my compulsory.
Relation and Belgium.
Who views the grammar? That is also.
Two views at this stage,
I agree, man. But now also we find.
because recent decisions of the Supreme Court that glaring.
So, now, glaring what I find my lord, the only glaring is that in the Lana court will have based on 9 and 10. 9 and 10.
Hmm.
And 8 also discussed when the Lana court below. 8.
Hmm.
7, 8, 5, 7. Lana court will discuss about 8 also.
Two. The principle underlying the theory. Question is also the test. Also, a test is that whether they have a fair chances of acquittal.
Lordship.
That is also a test.
And the gravity of the offense.
Gravity is already we know.
I know.
302
I know.
life. But question is also whether there are fair chances of acquittal.
My lord.
Now, only basis is that extrajudicial confession and plus that 164
Yes. I know.
and
And the surrendering part, the surrendered.
surrender only a conduct under section 8
I know.
that can aid.
I know.
But what are the substantive piece? Substantive piece of evidence is only extrajudicial confession. The other part 164 would be a corroborative one,
Lordship.
right? And there was no evidence of last seen together with
Not
Rohim.
Yes.
Rohim confession is there, extrajudicial,
Yes.
but there no evidence established as a fact that Rohim was seen together with the deceased.
Yes. Not there.
There is no evidence to that effect. So, question of his explanation also does not come.
And the ones who.
Say 106. Standing alone, this extrajudicial confession, whether it will be enough to result in conviction of the applicant,
Another factor, my lord.
then whether he has a fair chances of acquittal.
Acquittal.
If he has a fair chances of acquittal, then that is one of the consideration at the stage of 389. So then if he has fair chance, then why he should be incarcerated in
Lordship.
jail? And you know, from 164, we have already discussed what is the defect there.
Lordship. Yes,
That is ex specie apparent.
That Lordship, his extrajudicial confession, I mean to say it tallies with the injury, and whatever is stated, it tallies. The
Whose?
Gamusa and all.
No, he has not made any. He has made. He has
Extrajudicial
said, oh,
confession before
he
honor-
killed.
Yes. With
That is his.
Gamusa.
Huh?
Contents are there. They had a love affair.
Love
They
affair,
went
yes.
out.
But where is that Gamusa?
There.
Where is that Gamusa?
Lordship. Lordship, that factory is dead. They had an affair. They went out and had intimate
PW
relations.
eight, PW eight.
Before.
I
I'll
think
next day I'll
PW
say
eight,
that.
PW eight. But whether it has really come on record? Mr. Amit,
Then PW eight, before PW eight.
first
Lordship,
part you have
page
done,
18,
first
page
part you have
18.
done correctly, but second part you have not done correctly.
Page 18, my lord.
Ah, I've
Just a
seen.
minute. He went to the house of Satar. When all went to sleep, as earlier, he took Aswanu to the Morakoti where he indulged sexual intercourse with.
Find out, it can be read in evidence from that one. Supreme Court.
Lordship, may I pray, since the evidences are in Vanikula, let a paper book be prepared and
No, no,
entire
no.
matter be fixed.
Since you have
If they have a
had
clear
the
chance
pap-
of acquittal.
no, had the paper book been ready, I could have heard the appeal, but it is not ready. So from the materials on record, we can consider. Next Wednesday then,
Wednesday.
to come up with anything substantial.
No.
HRS Udri, Senior Counsel, esteemed Mr. A. Ahmed, for the applicant appellant, B. Bhuya, learned additional public prosecutor for the respondent state. Full stop. List the case on Wednesday for consideration of the application under section 389 CRPC. No, find out if anything is substantial, because I don't have more than 24 hours memory.
Item 14.
That is difficult, Mr. Counsel. Next.
Item 15.
Consideration.
This thing is for life under section 302, relying on the evidence. The sole eyewitness. However, the version of the eyewitness is very much different in different stages. In 161.
So, else here. Else here. Where is the FIR?
Page 1 of my paper.
Exhibit 2 করে আছে এটো নহয় আৰু এটা এক্সিবিটৰ থাকিব এটো নহয় এটো নহয় এটো নেকি ৰ'ব এটো নহয় exhibit ইয়াতে আছে নেকি এটো evidence statement list of exhibits okay FIR
So lottery is ordained by paper book is available at page 1. The counsel.
I am holding the original one. Okay. FIR. FIR exhibit P4. Yes.
B-storage 2022, তারিখে ইন্ডিয়া প্রাইস তথা কৃষ্ণন বাজার মূল লড়া রতন বর্মন শ্রীমতী সরলা মন্ডল ভিলেজ নগর মতল বিনা কারণত ইউনিট সুরেৰে আঘাত কৰা মূল লড়া রতন বর্মন সাথে নিহত হয় গতিকে দয়ালু মহোদয়ৰ বিচাৰ ৰবি ডিভিজন It's the FIR was by the father of the deceased. As for the particular story, one Renu Burman was present the time of the alleged incident. Our statement was recorded under section 154, which is available at page 19.
In front of Nick on the unit inside stab wound below. 3 cm thyroid cartilage of adjacent. Damages sufficient to cause death of inordinate force. Why 164? Let us turn to some main evidence testimony.
Yes, 164, because as per Renewable Burman, he was very much present at the
No, why 164? Come to the main evidence.
main evidence your lordship will find at page.
That cannot be treated as evidence.
No, I wanted to show the contradictions.
Oh, contradiction, if you have brought contradiction on record, then only we'll consider. How first, let us see the substantive evidence.
PWC,
PW3.
page 29 of the report.
PW3. Renewable.
Okay.
Bormon. Yes.
I may read more.
Read, which part you want to show?
PWC, the evidence.
Hmm.
I know information related to the Burman.
We have read, which point you want to?
Like prospered. There are houses of Govindo Rai, Kartik Mandal, Pushpa Rai, Tulsi Burman and Jindu Burman adjacent to my house. During my event prior, they came to the place of occurrence. But the above mentioned people did not see the incident of stabbing that was on the road. The occurrence took place at about 6:30 PM. It was getting dark. It is not a fact that the relevant time of incident, Ratan Burman was standing in front of my house. It is not a fact that I had not asked the accused why she did not bring my husband as she made him drink alcohol. The husband was not examined. It is not a fact that I had deduced falsely that accused Sarala Manasi did not tell me that she would slap me. That part was missing in 161 statement.
Now what? How you have second eyewitness account of Sorla PW3, that is what I want to know.
For this one, I take the proceed to the evidence of IO. Because the IO was confronted with the question whether Sarala Burman deposed before him, stated before him the alleged incident now. he has-
But where is that? How you have set up the case in cross-examination? Where?
Fact that I have deposed-
Oh, this is not setting up, bringing contradiction.
But the contradictions are from 161 to 164
How?
and the evidence.
How? When will,
161 that
we cannot read. You have not brought it.
I have brought it through IO. Lord. The IO. to-
IO, first you have to brought it to the PW.
This is, it is not a fact that.
Oh, this is not the way.
But whenever we will cross-examine the party.
Then perhaps faulty.
You would say it is not a fact. But
That is
part-
suggestion.
That part.
That is not contradiction, Mr. Biswas.
Well, contradiction, my lord, is.
If she admits, if suggestion means that this is one, then if she admits, you basically cross-examine with reference to 161 and other materials, right? Or a defense case. When she denied and nothing more is done by the defense,
Beside putting suggestion, no option is left.
there are many options, Mr. Biswas.
161 and 164 and the resolution, there are contradictions. So that contradiction will rise. But there is no contradiction, there cannot.
B. Bhuya, learned. Senior counsel and additional public prosecutor for the respondent state, assisted by MS.M. Chakraborty, opposite party, now opposite party state. Assisted by MS.M. Chakraborty, learned counsel. First of, the instant application under section 389(1) CRPC is prepared seeking suspension of the execution of sentence passed against the applicant, appellant, and for her release on bail. Full stop. The applicant, as the appellant, has preferred the accompanying criminal appeal, criminal appeal J number 44. You are legal aid counsel, learned legal aid counsel. Criminal appeal number, appeal J number 44 of 2024. against the judgment and order dated 11/8/2023, passed by the learned Sessions Judge Baksa at Musalpur in Sessions Case Number 189 of 2022. Full stop. By the judgment and order dated 11/8/2023, the applicant appellant has been convicted for the offense of murder under Section 302, IPC, and she has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 2,000, in default of payment of fine, to undergo simple imprisonment for another 2 months. Full stop. The accompanying appeal, criminal appeal has already been admitted for hearing. Full stop. Para. Yes, Mr. Vishwas. What are the points?
Points I am arguing because there are contradictions in the evidence of the PW. The Variable Vermont, the PW3 was stated before the police that he was present at the time of the incident.
Learned counsel for the applicant appellant has submitted that the witness projected by the the witness projected by the prosecution as the eyewitness, PW3. Prosecution witness, PW3 has been projected by the prosecution as an eyewitness. Full stop. It is contended that there is glaring inconsistency in the testimony of the said witness PW3 vis-a-vis her statement recorded under Section 161 CRPC. Full stop.
So when recovered, it was not under seal, not necessary for FSL to verify that this is.
Okay, the alleged weapon of assault, a knife, though it was admittedly of the applicant appellant, was not sent for serological examination to the forensic science laboratory. And in the absence of any FSL report, the appellant could not have been connected with the alleged death of the disease, Ratan Burman. Anything?
The witness that those who were present, as stated by the IO at the time of recovery of the weapon, the signature of the executive magistrate who was present was for taken in the serial list. And 2 persons who were present, he has stated a different story in the evidence.
Seizure witnesses what?
The witnesses, as per IO, 3 persons were present along with the accused
While seizing the,
while seizing the knife from.
okay. Mr. Vishwas has further submitted that 3 witnesses were present at the time of seizure of the knife, Matt EXT1, but none of those witnesses were examined.
Except 2, this other executive magistrate was also present at the time of seizing the knife. Neither it was examined nor its signature was obtained.
In 3 witnesses, including an executive magistrate, but the executive magistrate was not examined by the prosecution during the trial, though the other 2 witnesses to the seizure were examined by the prosecution.
The incident occurred suddenly at the heat of passion. There was no criminal intent or motive.
He has further contended that the incident, the alleged incident of assault occurred suddenly And as such, there was no premeditation on the part of the applicant appellant, full stop. Yes, MS Mia.
Oh, shit. I'll be relying solely on the evidence of PW3. my lord.
MS
I
Mia,
witness.
learned additional public prosecutor, has referred to, has submitted that the case in hand is based on direct evidence. Full stop. The prosecution witness, PW3, was an eyewitness to the incident of assault, which resulted in the instantaneous death of the deceased, Ratan Bormon. As the testimony of PW3 was not discredited insofar as the core of the prosecution case is concerned, the question of consideration of suspension of the execution of the sentence passed against the applicant does not arise. Full stop. We have given due consideration to the submissions of the learned counsel for the parties and have perused. We have gone through the materials, evidence stroke materials on record for the purpose of consideration of the instant application preferred under section 389 CRPC. Post. From the testimony of the autopsy doctor, no, sorry, the FIR was lodged in connection with the alleged murder of one Ratan Bormon. Full stop. From the testimony of the autopsy doctor, PW1, and the post-mortem examination report, EXT P1, it emerges that the deceased sustained an incised stab wound below 3 centimeter thyroid cartilage of size 2 cm into 5 cm within bracket depth in front of the neck. Full stop. The larynx and trachea was found perforated with bleeding into the larynx and mouth, and nerve and muscles were incised. Full stop. PW1 testified to the effect that the nerve injuries sustained by the deceased were sufficient to cause death of a person in ordinary course. Full stop. He opined that the cause of death was due to shock and hemorrhage following stab injury in front of neck, leading to perforation of trachea and injuring right laryngeal nerve, adjacent muscle and blood vessels. Full stop. PW3, who was with the deceased at the time of the alleged assault, testified to the effect that After a brief argument between the deceased and the accused, the accused brought out a knife from inside her blouse and stabbed on the neck of the deceased. And thereafter, the accused fled away from the scene by riding a motorcycle or bicycle. PW3 also stated, during her cross-examination that the accused used to carry a knife along with her. Post. PW6 deposed to the effect that on the date of the incident, at about 6:30 p.m., when she was at her home, she heard hue and cry from the road. Hue and cry of PW3 from the road, shouting that the accused killed the deceased. After hearing the same, when she went to the place of occurrence, she saw the accused leaving the place by riding her motorcycle, and the deceased was lying on the side of the road with profuse bleeding from his neck. PW7 also reached the place of occurrence on immediately after hearing hue and cry of PW3 from the road, and going to the place of occurrence, he saw the accused leaving the place of occurrence by riding her bicycle, and the accused was found lying on the side of the road with profuse bleeding from his neck. PW8 also reached the place of occurrence after hearing hue and cry from PW3 immediately after the occurrence. And at the place of occurrence, she saw the accused going on the road by riding a bicycle. She witnessed the presence, PW8 witnessed the presence of PW3 on the road, and it was PW3 who reported to PW8 that the accused stabbed the deceased on the neck. PW8 also claimed to have witnessed the deceased lying on the right side of the road with blood oozing out from his neck. Para na lage. In her examination under Section 313, the accused sought to explain that it was the deceased who tried to commit rape upon her. and due to the scalpel, hard knife hit on the neck of the deceased host. While deposing as DW1, the accused admitted her presence at the place of occurrence. Full stop. Having considered the above evidence stroke materials on record, we are of the privacy view that we find that the PW3, so the eyewitness account of PW3 appears privacy cogent and credible, and the said witness and the defense failed to discredit such eyewitness account of PW3 in any manner so as to create a dent in the case of the prosecution. Full stop. The evidence of the three prosecution witnesses, PW6, PW7, and PW8, are privacy admissible under the rule of res judicata. Full stop. From the medical evidence, which are in the form of PW1, testimony of PW1, autopsy Dr. PW1, and a PME report, exhibit EXT P1, the death of the accused was evidently a homicidal one. Full stop. Para. The question whether the accused, case of the accused, would come under any of the exceptions to Section 300 is a matter which requires consideration at the stage of hearing and upon detailed appreciation of the evidence on record. Full stop. Para. Having considered para. It is settled proposition that in considering a prayer for bail in a case involving a serious offense like murder punishable under Section 302 IPC, the court should consider all the relevant factors like the nature of accusation made against the accused, the manner in which the crime is alleged to have been committed, the gravity of the offense, and the desirability of releasing the accused on bail after he or she has been convicted for committing the serious offense of murder. Full stop. Having considered the case of the appellant, keeping the above factors in purview, we do not find that the case in hand is a fit one for exercising the discretion under Section 381 CRPC. Full stop. Finding the application bereft of any merits, the application by instant application is dismissed. Full stop. We have, it is however made clear that the observations made herein above are only for the purpose of considering the application of the applicant appellant under section 389 CRPC, and any of such observations shall not be construed as observations on merits as regards the accompanying appeal. Absolutely bad case. Only a case for exception.
Considering a situation, carrying
Many are in line, Mr. Vishwas.
a child.
Paper book in the main criminal appeal, hired Mr. S. Vishwas, learned counsel for the applicant, learned legal aid counsel for the applicant appellant, and MSP Bhuya, learned senior counsel and additional public prosecutor. For the respondent number 1 state, assisted by MS M. Chakraborty. From the report forwarded by the Chief Judicial Magistrate Baksa Musalpur, it is found that the service of notice upon the respondent number 2 has been duly effected. Full stop. Thus, service of notice upon the respondent number 2 is treated to be complete. None has appeared for the respondent number 2 despite service of notice till date. Full stop. As the records of the trial court have been received, office to take steps for preparation of the paper book, release the case after 4 weeks. Did you operate the paper book? Okay. Okay. 9 rupees, 9. Exception, exception, prejudice, 3টা আছে। Defense evidence deal easy করেছে 313 ওটা appeal করেছে। এই report story তো যদি false হয়ে যায়, এই report রাস্তা লোক করিব না আর পাবলিক এর কথা বলে। হুম? Essay received, paper book. Hard MS D. Borpujari, learned legal aid counsel for the appellant, and Mr. Kekedas, learned senior counsel, learned additional public prosecutor for the respondent state of Assam. Full stop. As the case records of sessions, case number 17 of 2022 have been received, command the office to take steps for preparation of the paper book. List the case after 4 weeks.
Item 17.
Done or not? You have not taken steps. Huh? When? Heard Mr. Jedas, learned legal aid counsel for the appellant, and Mr. Kekedas, learned additional public prosecutor for the respondent number 1, state of Assam. Full stop. Mr. Das, learned legal aid counsel, has submitted that he has taken steps for service of notice upon the respondent number 2 by registered post AD as well as by usual process recently. কেতিয়াবা নাহে তেওঁ লোৱা বুলি কয় 28 has submitted that he has taken requisite steps for service of notice upon the respondent number 2 by registered post with AD as well as by usual process. এইটো কেতিয়া? এইটো ঘূৰিয়ে অহা নাই? অ'কে 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 ৰিচিপ্টটো হৈছে নাই? অ'কে, নালাগে এইখিনি লিখিব। In view of the office note dated 9/8/2024, await for the service report in respect of the respondent number 2. Full stop. As the records from the trial court have been received, the office to take steps for preparation of the paper book. Full stop. Release the case after 4 weeks for report as regards service of notice upon the respondent number 2 and as regards preparation of the paper book.
Madam, 18.
Aye. Do we? Aye. Press appeal. Wrongly listed in order. Right? Yes, Mr. We'll admit. First time it has come. Heard Mr. MSek, learned counsel for the accused appellants, and Mr. KK Das, learned additional public prosecutor for the respondent number 1 state. Post up. The instant criminal appeal under section 415 of the Bharatiya Nagorik Suraksha Sanhita 2023 is directed against a judgment, an order, judgment or sentence to elect Niki. Okay, judgment dated 18/6/2024 and an order on sentence dated 26/6/2024 passed by the learned Sessions Judge Udalguri in Sessions case number within bracket Roman capital Roman 1 number 06/2019. Post note. 5 appellants. 5.
Yes.
Okay. By the judgment and order, by the said judgment and order, the accused appellants have been convicted for the offenses under sections 148/149/302 of the Indian Penal Code. And they have been sentenced to undergo rigorous imprisonment for life and to pay rupees 10,000 as fine, in default of payment of fine, to undergo simple imprisonment for another 2 months. It will go for the offense under section 302. For the offense under section 148 IPC, all the accused appellants have been convicted or sentenced to undergo rigorous imprisonment for 1 year. So it has been ordered that the sentences shall run concurrently. So we have perused the contents of the memorandum of appeal. The criminal appeal is admitted for hearing. The records of sessions case number so and so be called for. Issue notice returnable in 4 weeks. As Mr. Das, learned additional public prosecutor, respondent number 1, dispense to it, extra copy. The appellants shall take steps for service of notice upon the respondent number 2 by registered post as well as by usual process within 3 working days from today. Release the case after 4 weeks. After LCR, then we'll issue notice.
Item number 19.
J Mullah. Huh? First time? You can. Huh? Oxo.